spectators.
Okay. Ms. Dennis, will you raise your hand and be sworn, please?
Yes, please.
Do you solemnly swear or affirm the testimony you're about to give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may lower your hand and counsel may proceed.
Would you state your full name and address for the record, please?
Deborah Lynn Westmoreland Dennis,
Where do you reside?
3112 County Road 2744, Naples, Texas,
And
75568.
all right, and you're here today seeking to probate the last will and testament of James Andrew Rogers. Is that correct?
Yes, sir.
Did he pass away on April 3rd of this year at his home in Hugh Springs, Cass County, Texas?
Yes,
Was he 80 years old at the time of his demise?
yes,
And his permanent residence was at 623 County Road 2866, Hugh Springs. Is that right?
yes,
Now, he had a will dated October 21, 2020. Is that right?
yes, sir.
To the best of your knowledge, that will was never revoked by him. Is that correct?
No, sir, was not.
And that will was actually prepared by me. I was his longtime attorney. Is that right?
Yes, sir.
Okay. Now, we've delivered the original will to the court, and you've seen that will. Is that right?
Yes,
And you'd seen that. Had you ever seen that will before?
I had a copy. I had not seen the original.
Okay. Now, he had children all long since estranged from him. Is that right?
Yes,
Okay. And I mean, you're familiar with his circumstances because you're a CPA. Is that right?
yes, sir.
And you had done his taxes for him for years. You had helped him in various things he had done for years. Is that right?
Yes, sir.
And is it your understanding that when he came to you, I mean, when he came to me, he told me he wanted to leave his property to you, being the only person that really he had any connection with here other than me as his lawyer. Is that right?
That is correct.
And did you have to discuss with your husband whether you wanted to receive any property from Mr. Rogers?
Yes.
Now, he doesn't own much, does he?
A two-bedroom double home, mobile home, and the lot it sits on, and some very old equipment there.
Okay. Other than that, he doesn't have a bunch of cash that you know
Not that
of,
I'm aware of. No.
investments that you recall. anything like
Never
that?
on a tax return did he have anything like that.
Okay. Now, he didn't have any children born to or adopted by him after he made this will last fall, did he?
No, he did not.
He didn't divorce after the time he made this will, did he?
No, he did not.
That will does name you as his independent executrix, and you're willing to carry out the terms of his will. Is that correct?
Yes, I am.
And you understand that if the court does grant you letters testament in this case, you'll have an obligation to do various things, file an inventory and appraisement with the court once you determine what all his assets are, take care of any creditors' claims that might exist, and then distribute his assets in accordance with the will. Is that right?
Yes,
That will does not name any governmental agency or the state of Texas as a debasee, does it?
no, it does not.
It actually just gives everything to you, or if you were predeceased, to your husband. Is that right?
Yes, sir.
And the will was properly self-proved here in my office with witnesses and notary as required by law. Is that correct?
Yes,
Are you asking the court to give legal effect to Mr. Rogers' will as he prepared it here in my office and signed here in my office on October 21, 2020, name you as the independent executrix to serve without bond, and let you carry out his wishes? Is that right?
yes.
I pass the witness, Your Honor.
I have no questions. Anything further, Mr. Stovall?
No, Your Honor.
The court finds that the document filed with the court is in fact the last will and testament of the deceased. The court finds the will was made self-proved as required by law, therefore no further proof is necessary. The will is ordered admitted to probate. The applicant is appointed as independent executrix to serve without bond. No further action will be required by the court other than the filing of an inventory appraisal and list of claims upon the applicant qualifying as independent executrix as so named in the will.
Thank you, Your Honor.
And Ms. Dennis is excused.
Thank you, Your Honor. We'll
Thank
file, The order has been e-filed, Your Honor. We will thereafter submit the oath and proof of death.
Very good. Yes, ma'am.
Some exhibits just found a little bit down.
What's that? What case is that in? Okay.
Or, I guess
No,
one or two.
okay. It's not this one, but it's one of these. Okay, all right. Next case for the record is CCL 21D063 in the matter of Jessica Vivian Rester and Thomas James Rester. Is the petitioner ready?
We're here and ready, Your Honor.
And is this a waiver or default?
It's a waiver, Your Honor. It was file marked, I think, back in early March. Yes, sir. March the 4th, Mr. Thomas James Rester executed and filed a waiver of service. Although we did notify him of today's court and he has signed the decree.
Okay, yeah, it is in the file, so you may call your first witness.
Called Jessica Vivian Rester.
Mrs. Rester, will you please raise your hand and be sworn, please? And do you swear or affirm the testimony that you're about to give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. I'll need you to speak out. You have a soft voice, so you can lower your hand.
Yeah.
All right, you may proceed.
Would you state your full name for the record, please?
Jessica Vivian Rester.
And for the court reporter, that's Jessica, Jesica, just one S, is that right?
Yes, sir.
All right. And you're currently married to Thomas James Rester, is that correct?
Yes, sir.
At the time you filed this suit for divorce that the court has just called, you had been a resident of the state of Texas for the preceding 6 months and a resident of Cass County for the preceding 90 days. Is that right?
Yes, sir.
Did you and Mr. Rester marry on or about October 5 of 2006?
Yes, sir.
Did you cease living together as spouses on or about this time last year, May of 2020?
Yes, sir.
Did there arise in your marriage discord or conflict of personalities that has destroyed the legitimate ends of your marriage relationship?
Yes, sir.
Is there any reasonable expectation that you and Mr. Rester are going to reconcile your marriage at this point?
No, sir.
You asked the court to grant a divorce to you on the grounds of insupportability. Is that correct?
Yes, sir.
Now, the two of you are the parents of 2 minor children. Is that correct?
Yes, sir.
Damian Alexander Rester is now how old?
He'll be 17. He's 16.
He'll be 17 tomorrow. Is that
Yes.
right?
No, the 21st.
Oh, in 4 days. I'm sorry. And Reagan Elizabeth Ann Rester is how old?
14.
All right. And have the two of you reached an agreement that provides that you will be joint managing conservators of those children, with you having the primary right to establish the children's domicile?
Yes, sir.
And he is to have visitation under a standard possession order. Is that right?
Yes, sir.
Have y'all already been doing that?
Yes, sir.
Y'all don't have any difficulty when it comes to the children, do you?
No, sir.
The two of you have put your children's interests first. In fact, he's coming here and talked with us, and he loves his kids and wants to make sure he has his access. Is that right?
Yes, sir.
And do you believe that the terms of the agreement regarding conservatorship and possession are in the children's best interest?
Yes, sir.
Have we also computed child support based on his earnings through his employer and Tyler?
Yes, sir.
And that child support amount based on his earnings for the 2 kids is $1,182.58 per month. Is that right?
Yes, sir.
And he's agreed to do that starting April 15th of this year.
Yes, sir.
Now, when the first child emancipates or when there's only 1 child left for child support, the child support will reduce to $946.07. Is that right?
Yes, sir.
And do you believe, and also he's gonna provide health insurance for the kids
Yes, sir.
under his employer's insurance.
Yes.
And do you believe the terms of this agreement you've reached with your husband for the support of the children is in their best interest?
Yes, sir.
Now, the two of you acquired some property during the marriage and incurred some debt during the marriage. Is that right?
Yes, sir.
Have you also reached an agreement with your husband on how to divide up those assets and debts?
That's already clear.
And we've put all this in writing in the form of this final decree of divorce. You've reviewed it and signed it, and he's reviewed and signed it.
Yes, sir.
Do you believe the terms of this agreement with respect to your kids and with respect to your community estate is just and fair and right? Are you asking the court to approve it?
Yes, sir.
Are you asking the court for a name change or not?
Yes, sir.
You asking the court to restore your name to
Mhm.
Jessica, Jessica, Vivian, Vivian, Allison, Allison, Peacock, Peacock.
Yes, sir.
And that's in the divorce decree, is that right?
Yes, sir.
I pass the witness, Your Honor.
I have no questions. Is there anything further?
No, Your Honor, we rest.
The divorce is granted. The court finds that there are 2 children born as a result of the marriage, and that the parties have entered into a parenting plan which appears to be in their best interest. So it is now approved in all of its detail, including provisions for access to and support of the children. And it's incorporated in the court's judgment. Also, that the parties have entered into an agreement to divide their community property and estate, and that appears to be fair and equitable. It's also approved and now becomes the judgment of the court. And I will sign those orders when I receive them.
The name change is granted, Your Honor.
Name change is granted. Anything
Thank you, Your Honor.
further?
No, Your Honor, I believe we have e-filed the decree, the withholding order, and the request for issuance. And I would ask Ms. Doherty to get me a certified copy of the decree for the name change purposes.
Very good. She's online, so I'm sure she'll do that as soon as she can.
Thank you, Your Honor. May we be excused?
Yes, sir. Good luck on the meeting.
Thank you, Your Honor. I believe we'll get it done, maybe.
Next is CCL 21C 167, interest of SGJ. Mr. Allen.
Yes, Your Honor, we're present and ready.
I've just received a First Amendment petition to terminate parent-child relationship.
Yes, Judge, I filed that on Friday, asking for a change of the child's name to Skylar Grace Adcock.
That's the difference from the original petition?
Correct.
Okay. Then you may call your first witness.
Okay. Call Alexis McKenzie Adcock.
And let's see, I looked at this on Friday. I'm trying to refresh my memory. Yes, I recall it. She's the natural mother of the child and
She's the biological mother.
seeking to terminate the rights of the biological father.
Correct.
And as I recall, he's filed an affidavit of relinquishment. Is that correct?
That is correct, Judge.
Okay. All right. Please raise your hand and be sworn, please. And please speak out so we can hear you clearly, okay?
Yes, sir.
All right. You solemnly swear or affirm the testimony that you are about to give to the court will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
You may lower your hand.
Judge, can you hear her?
No, I
Okay.
can't hear her very well. I need her to speak a little louder.
Okay. You might have to see if you can switch chairs and maybe get just a touch closer. And just try to speak out as I ask you questions. Okay, would you, may I proceed, Your Honor?
You may.
Would you state your full name for the record, please?
Alexis McKenzie Adcock,
Okay, and Ms. Adcock, where do you currently reside?
202 West 3rd Street, Lot 1, Atlanta, Texas.
And are you the biological mother of Skylar Grace Johnson.
Yes.
And when was Skylar born?
December 15th, 2020.
And Robert Merrill Adcock signed an acknowledgement of paternity, which was placed on file with the Texas Department of State Health Services, their vital statistics unit. Is that correct?
Yes, sir.
And you both signed that document on or about December 16th of 2020, correct?
Yes.
That was about one day after Skylar's birth,
Yes.
right? And Your Honor, I have filed that as Exhibit A, and I would ask that that be admitted into evidence.
That's granted. The document noted is admitted into evidence, and the court takes notice of the contents.
And Ms. Adcock, I'll show you what I've marked as Exhibit A. Is this a true and correct copy of the acknowledgement of paternity that you and Mr. Johnson put on file with the state?
Yes, sir.
Have there been any other court proceedings regarding Skylar?
No, sir.
This is the first one, correct? Again, Robert Merrill Johnson is the acknowledged father of the child, and has he signed an affidavit of relinquishment of his parental rights?
Yes, sir.
With regard to the inheritance rights, we've alleged in our petition that once his parental rights are terminated, he will not be able to inherit from Mr. Johnson. And you agree with that, correct?
Yes.
In addition, we've asked the court to waive the appointment of an attorney ad litem because we believe that you can adequately represent your biological child's interests in this particular proceeding, correct?
Yes.
And you understand that the court will more than likely order the sealing of the file and the records after this proceeding today.
Yes.
And do you believe that termination of Robert Merrill Johnson's parental rights to Skylar is in Skylar's best interest?
Yes, I do.
And are you currently asking the court to grant the termination based on Mr. Johnson's affidavit of relinquishment of parental rights and waiver of service filed with the court on April 9th, 2021? That's all I have, Judge.
Ms. Adcock, you understand that the father of the child has a responsibility of support of the child. In other words, you could seek child support from him if his legal rights are not terminated. Do you understand that?
Yes, sir.
Do you feel that you are in a financial position where you can support the child without any help from him?
Yes.
Are you employed?
Yes, sir.
Where do you work?
I work at Cass County Equipment in Queen City, and then Eddie's Dog Grooming.
What was the second one?
Eddie's Dog Grooming and Boarding.
Okay. Anything further, Mr. Allen?
Nothing further, Your Honor.
The court finds by clear and convincing evidence that the natural father of the child, biological father of the child, is Robert Merrill Johnson as alleged in the pleadings and is acknowledged by him. Court finds that he has, by clear and convincing evidence, filed an affidavit of relinquishment of parental rights in accordance with the terms and conditions of the Texas Family Code. It is therefore the order of the court that his parental rights be, and they are hereby ordered terminated. The court finding further by clear and convincing evidence that such termination is in the best interest of the child. As the natural mother of the child, the petitioner is appointed as the permanent managing conservator of the child. The request for the child's name to be changed is granted. Let me find that.
Should be on the last page of my amended petition, Judge. There is a request to change her name to Skylar Grace Adcock.
And that's granted. And I will, for the best interest of the child, order the file sealed at this time, subject only to unsealing or disclosure upon order of subsequent order of the court, except for, and this is for the benefit of the clerk, any copies of any documents in the court order being signed needed by counsel for the petitioner at this time does not require court order.
Yeah, Judge, actually, we would probably request 5 certified copies of the order.
Okay, Ms. Darty's online, so I'm sure she heard you there.
Okay.
Anything further?
Nothing further, Your Honor.
All right, you're excused, your client's excused.
Okay, thank you, Judge.
And the next case is T&T Equipment Trust versus Benny Hall and April Hall. Is the petitioner ready? Plaintiff ready? I believe no, you're not muted. Can you hear me, Mr. Vershaw?
Yes, Your Honor, we can.
Very good. I have reviewed this file and it appears that the defendants, Benny Hall and April Hall, were personally served with citation. There is a return of service on file. It's on each defendant. There's no answer on file on behalf of either defendant, nor does either defendant appear either personally or by way of this Zoom meeting. Therefore, appears that the defendants are in default. So you may call your first witness.
Your Honor, I'll call Norman Moorhead.
Mr. Moorhead, will you raise your hand and be sworn, please, sir? Do
Yes,
you
sir.
swear or affirm that testimony you're about to give the court will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, you may lower your hand. And you may proceed, Mr. Vershaw.
Thank you, Your Honor. Would you state your name for the court, please? Norman Moorhead. And are you married to Linda Moorhead? Yes, sir. And do you all operate the T&T Equipment Trust as a vehicle to buy and sell property and equipment and personal property? Yes, sir. And during the time that this transaction was initiated and being carried out, you were the trustee for the T&T Equipment Trust. Is that correct? Yes. And then later, and more recently, we found an amendment to our abstract of a trust, appointing your wife, Linda Moorhead, as the trustee. Yes, sir. But all this transactions involving the parties here were while you were managing the trust. Yes, sir. Now, is it true that you sold a piece of property to the defendants, and it was 175 acres in Ingram, 1.75 acres in the Ingram survey? Yes. And is that just a house and a little bit of land there? Yes, almost sir. 2 acres. Yes, sir. And did you sell it to Benny Hall and his wife April Hall? Yes, sir. And with regard to that transaction, I have here that have been marked the 3 legal documents. One is a warranty deed with vendor's lien. You recognize that? Okay. And that's the property. That's the instrument conveying the property from T&T to them. Yes, sir. Okay. The next exhibit is Exhibit 2. And I'd ask you if it's true that this is a deed of trust. Yes, sir. Of the transaction between T&T and Benny and April Hall. Yes, that's right. And that is the deed conveys title. The deed of trust is a mortgage document. And then on plaintiff's Exhibit 3, the real estate lien note is that their signature at the bottom. It appears to be, yes. And that the note was dated concurrently with the deed and the deed of trust, and it calls for the payments and how much and how the loan is to be operated. Yes, sir. And like other transactions, Your Honor, I would offer plaintiff's Exhibit 1, 2, and 3, which is the Warranty of the vendor's lien is 1, deed of trust is 2, and then the real estate lien note is number 3. And Mr. Moorhead, you did say that the deed and the deed of trust have been filed for record in the office of the county clerk. Yes, sir. And they're in good order. Yes, sir.
All right, then, plaintiff's exhibits 1, 2, and 3 are received and admitted.
Thank you, Your Honor. Now, like other transactions, it went along okay at first, didn't it? Yes, it did. And then, did you have trouble with him getting behind in his payments? Yes. And also, you had insurance that he was required to produce, pay for it, and bring you a copy of the policy. Right. And it had restrictions in there about the amount of the deductible, 80% co-insurance, and those standard things. Right. Let me ask you to look at the plaintiff's exhibit number 4 and ask if you can identify that as my letter to the Halls dated July 30, 2018. You told me to send that letter. Yes, sir. Okay. And among the complaints that we had at that time was that he was supposed to take good care of the property. Right. And in addition to that, he was supposed to have 80% co-insurance with a qualified insurer that you agreed to. Yes. And then he was supposed to provide you with a copy of that policy at least 10 days before the old one expired. Right. And did he fail to do those things? Yes. And does plaintiff's exhibit number 4 represent those violations and your demand for him to correct those? Yes. And Your Honor, we would offer plaintiff's exhibit number 4.
I don't have that, Mr. Burchell. The only thing that clerk.
Tara just sent a text message or a message saying that they've been e-filed and she's processing them now and bring them over soon.
Okay, all right. Then exhibit 4 is admitted.
Thank you, Your Honor. Now, as it turns out, the Halls were not very good tenants, were they? No. And they didn't really keep, the place always looked like how would you say it looked?
I've seen city dumps look better than what their place looked like.
So on April 16, 2020, let me hand you what's been marked plaintiff's exhibit number 5 and ask if you can identify that. Is that my letter to them making another demand?
Yes, I believe it is.
And was that sent by certified mail return receipt requested?
Yes, and that's included.
And that's included in plaintiff's exhibit number 5.
Right.
Now, at that time, were the violations more serious?
Yes.
Did you find out from information in the deed records that the taxes had not been paid?
Right.
Part of them.
Yes.
And that Mr. Hall, at his own volition, went to an outside third party and borrowed money, about $8,000, to pay the taxes. Is that correct?
Yes.
And as a result of that, there was a tax lien, a transfer of tax lien from the Halls to this company.
Yes.
And so they own the tax lien. It was initiated after your note and deed of trust were agreed to, the purchase money.
Right.
It was down as several years later. But and so on plaintiff's exhibit 5, did I write him a letter and tell him he had 60 days to get a release of that tax lien and bring it back to me?
Right.
And the reason that's a violation is that it places a threat on your purchase money lien because it's for taxes.
Right.
And so then you asked me to get a copy of the lien from the clerk, is that right?
Yes, sir.
And a copy of the transfer.
Yes.
From the clerk. And So did you consider this a pretty serious violation?
Definitely.
Because it was for $8,000, and of course there's penalty and interest added to that. And did he eventually bring me a release of lien for that tax?
No,
And there's not a release shown on the tax records at all.
not that I know of.
And you asked me to look.
Yes,
Your Honor, would ask the court to admit plaintiff's exhibit number 1 as our demand letter outlining the various violations that the purchaser had incurred himself.
You mean number 5? The last exhibit was
Yes,
number
right.
5.
Yes, number 5. Yes, Your Honor.
All right, exhibit 5 is admitted. Thank you.
Mr. Moore, let me hand you what's been marked as plaintiff's exhibit 6 and ask you if you can identify that as a copy from the real property records in Cass County of the tax lien transfer contract.
that's what it's titled as, all right.
And the Halls have signed it. It is from the Halls.
Yes, 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 she has signed it.
And he signed it.
Yes, yes, they both have signed it.
And that is transferring the lien to a company IGMS Holdings LLC. Is that correct?
That's what it says, yes.
And as of this date, the taxes or the tax liens have not been paid off.
Right.
And that's, you consider that a pretty serious violation,
Yes,
and
definitely.
which is in your prerogative as the beneficiary under the deed of trust. And lastly, let me hand you what's been marked plaintiff's exhibit number 7. And ask if you can identify it as a sworn document authorizing transfer of tax lien.
Yes, yes,
And that is signed by Benny Hall and April Hall to that same company.
yes,
And this also is filed in the real property records of Cass County, Texas.
right.
And that's where they're authorizing the transfer of the lien, authorizing the clerk to make that transfer. They're correct?
Yes,
Now, back when the payments got slow, did you try to work with Mr. Hall to resolve the problem?
yes, we did.
And he was about $7,000 in arrears, is that right?
Right.
Excuse me. And did you even ask Mr. Hall if he could try to borrow money elsewhere and pay you off?
Yes, I did.
And did you order me to have meetings with him periodically to see how he's doing and bring me his records to show he'd been to this bank or this credit union, different places?
Yes, I did.
And was he ever successful in finding a new lender?
No,
Did you even offer to discount the balance of the note far enough down to where he might qualify for a loan?
yes,
And that was to encourage him to make the deal and pay you off as much as you can get.
yes,
And that was just going to be, but you were willing to do that for him,
yes,
but he never got it done.
that's right.
And did you order him to leave the house?
Yes,
And what condition did they leave your property in?
a royal mess. One bedroom was a city dump.
Did they have food in the refrigerator and
Food spoiling in the refrigerator, dog poop in the bathroom. It was a royal mess. They weren't fit to live there anywhere.
And did all these events cause you to file the suit and to seek a judicial foreclosure on the property.
Yes,
And that's what you're asking the court for today.
that's right.
Your Honor, in our pleadings, the dollar amount is set forth. And we're also asking for court costs and attorney fees. Before I testify about attorney fees, does the court have any questions for Mr. Moorhead?
Mr. Moorhead, do you know the current arrearage on the real estate lien note? How much
I'm
is
sorry, I
owed?
didn't hear you.
Your Honor, it's set in our pleadings. Original petition is about $9,000, I think.
See if
might
I
be
can
two.
find that. Under paragraph 5, it says $7,854.02 plus interest through November 2020. Is
That's right,
that,
Your Honor. We're satisfied with that amount. We're not gonna calculate up through today. We're satisfied with that pleading for.
it also alleges that the note payment was, at the time the petition was filed, delinquent, I believe,
143,000.
well, the note payment itself hadn't been paid for 9 months. Is that correct, Mr.?
That's right, Your Honor. And then during the period he was trying to get financing, he didn't pay anything.
Mr. Moorhead, do you agree with what your lawyer's telling me?
Yes, sir.
Okay. So when did the Halls vacate the property?
What, a month ago?
Well, it's when they were served.
Yeah.
And
Oh,
that date of service would be when they started moving out. It may have taken a week or two.
Yes.
And so they vacated the property on the date of service, which was November 13, 2020, which is a year ago.
Have you, Mr. Moorhead, have you received any payments in the last year from
no,
the,
sir.
from the Halls? So they're at least 1 year behind, is that correct?
Yes, sir.
Okay,
Yes, sir.
all right. Anything further, Mr. Bershaw?
Yes, Your Honor, I'd like to have an opportunity to testify as to attorney fees.
Do you swear or affirm your testimony to be the truth, the whole truth, and nothing but the true self you got?
Yes, Your Honor, I do. My name is James H. Verschoyle. I'm licensed to practice law in the state of Texas, and I have been practicing since my date of induction, or when I became a lawyer in 1970. My practice has been in Northeast Texas, primarily in Cass County, Bowie County, Marion County, Upshur County, and Titus County. I'm familiar with the rates charged in this community for these civil matters, and my rate is $200 an hour plus court costs. And in this case, we spent at least 14 hours, and I'll have to get the court costs from the clerk. They'll tell us on the record. We're seeking that. And then we had a $200 charge from the private process server for the citations that he served on defendants back in 2020. These fees are usual, customary, and appropriate for this type of work in Cass County, Texas. And these cases take additional time because of the way the cases are structured. I believe 14 hours of actual work. So we're asking the court to for reasonable necessary attorney fees, proper in Cass County for 14 hours, plus the court costs appearing on record and the process fees for serving the defendants in 2020.
All right. The original note was for,
$143.
the principal was 133,000 plus interest.
Right?
Mr. Moorhead, can you tell me the current amount, the total amount due on the note that's not been paid?
Total amount due what?
Total amount due on the note.
I don't have those figures with me, no.
We have an amortization schedule, Your Honor, and I can give the court a balance, but I'd have to go to my record. But the
Are you
original
asking,
amount.
are you asking for a judgment for the total amount of the note?
Yes, Your Honor.
Then I'll need the figure.
Well,
I need to know what that is.
Your Honor, I've got it on an amortization schedule. I'll have to present it to the court.
Do you have it there with you?
I
mean, I'll let you get it.
believe, Your Honor, it should be $133,000 even.
No, that's the original principal.
No, the original principal is 143, I believe.
Yes.
That's not what the note said.
Well, now let's see.
I'm looking at exhibit.
You're right, Your Honor. No, I'm sorry, you're right, it's 130. 143. No, that's it. Your Honor, you're right. I'm looking at the note itself, and it is 133,000. And I have an amortization schedule. Here it is.
What I'm asking is this, the note was made in 2015 in May. I assume they made payments on the note and then became in arrears.
That's right, John.
And I need to know the amount, the total amount due on the note at the present time after they became in arrears.
Your Honor, we calculated that through March 15, 2021, and the balance owed, or the unpaid balance would be $90,470.21.
21 cents?
Yes, Your Honor.
$90,470.2.
$21.
Okay. Anything further?
No, Your Honor.
All right. First of all, the court finds that the defendants did execute a real estate lien note, and there is contained in the deed to the defendants a vendor's lien retained in behalf of the sellers, T&T Equipment Trust. The court finds that the parties, that the defendants are in arrears on that real estate lien note in the total amount of $90,470.21. The real estate lien provided for in the note is therefore ordered foreclosed. The court orders the property to be foreclosed upon and disposed of in accordance with the terms and conditions of the deed of trust. File with the court. And I believe that is Exhibit 2. Judgment against the defendants in behalf of the plaintiff is rendered in the amount of $90,471.21. Also, the plaintiff has awarded attorney's fees in the amount of $2,800 together with all costs of court, all taxable costs of court incurred. If you'll draw those orders, I'll sign them. Anything further, Mr. Bershaw?
And nothing from the plaintiff, Your Honor.
All right, that'll conclude this hearing. Court's adjourned.
Thank you for hearing us, Your Honor.
Yes, sir.